Welcome to the Personal Injury Law Show, viewers. This is the show where we talk about everything relating to personal injury and how it relates to you, the viewers. My name is Nunzio Tartaglia. I'm a partner in an insurance law firm in Victoria. And with me tonight, I have John Karantzis, another partner in the Workcover division of a major law firm. John?
Hi, viewers. Hi, Nunz.
And also Jessica Rosla, a solicitor at an insurance law firm in Melbourne. Jess?
Evening, Nunzio. Evening, viewers.
Well, tonight's episode's a medical negligence update, and we've got some really interesting cases to tell the viewers, and that'll be in the next upcoming segments.
However, before we get to that, Nunz, what's in the news?
John, this is one that's close to your heart, and you've been very close to it, the Fiskville Compo Fury.
It's the blight that is Fiskville in Victoria, Nunzio. There've been hearings going on in the Victorian Parliament. We hope that Martin Pakula, the State Attorney General, enacts legislation protecting, not only protecting the locals that lived around Fiskville, and that's what this article is about, how they watched people die over the years from the cancers that they contracted, but also the CFA firefighters that worked at this training ground for years, Nunzio. It's an ongoing issue. We hope that the Victorian Labor Party enacts protective legislation.
And Jess, there's issues about the livestock which is in and around the Fiskville area. What's happening there?
Yeah, so John is right. There have been hearings, and I think an interim report has recently come out.
Yes.
Where recommendations have been made for the government to compensate the farmers who have lost livestock as a result of the cancers, like you said, John. So, I think it's a good start, but there's still a long way to go.
John, my concern, though, is, this has been in the news for how long now?
Oh, years.
Yeah, and
years.
What's happened?
Not much.
And that's my concern. What's the hold-up? Is it because it's too big, they're just worried where the can of worms may lead?
Exactly. Nunzio, the Victorian Workcover Authority, they're an insurer. Yeah. There's only so much pie, there's only so much money in the pie. Now, I'm sure the government actuaries are counting the pennies, and they're thinking, gee, if we open the floodgates, well, this could cost millions and millions of dollars. And it will. But at the same time, Nunzio, we have workers that have died at the workplace. Their families deserve compensation.
And they deserve it now, to be honest with you.
Exactly, now. And these injured workers that are dying of cancer, they don't want it once they've died. It's too late. Yeah. They need it now. Look,
it'll be an ongoing issue, but I'm sure we'll get back to it again. John, another interesting one. A professor loses case of harassment against Monash University.
Yes. Now, this is a case that Dr. Chen took to the federal court regarding harassment, discrimination claims. It went to the federal court, Nunzio. Dr. Chen lost her claim. Now, she made detailed allegations of discrimination and harassment by co-workers at the Monash Hospital. The federal court found against her, did not find her to be a witness of truth.
Credibility, yeah.
The credibility was a big issue, and not only did she lose the case, but she has to now pay legal costs of at least $900,000 to the Monash Hospital.
Well, Jess, tell the viewers, this is an example of, it's great having a case, but you've got to actually know that you've got a case which you can prosecute, because if you don't, there's also exposure when it comes to losing your case. And, she's up for almost $1 million worth of legal fees.
Yeah, that's right, Nunzio. I mean, I think this case highlights the real difficulty that some plaintiffs can get into when they're fixated on their circumstances, and it's difficult for them to understand how that fits in the legal context and whether that can amount to an award. And in this case, it's backfired, it seems.
The article suggests that she received some legal advice early on because they did make an offer of settlement of, I think it was $30,000, which obviously is not a lot. That's not what she was after, but the advice was, you're not going to win this case, and she didn't adopt that. So going against her solicitor's advice, the courts punished her.
Exactly.
John, another one's close to your heart, Izzy wins dog fight.
This is a classic castle-type scenario, Nunz. Izzy, a little puppy, has been saved from the death sentence. Now, it's a council in Melbourne, the Knox Shire Council.
Yep, that's one.
They took this matter all the way to the High Court of Australia. this little puppy, Izzy, allegedly, bit the finger of a person, caused severe, serious injuries, apparently. The council wanted to put this dog down. Now, my understanding is the High Court ruled that there was a bias on the council board in that one of the members was not impartial, had a bias. And, well, the High Court found that no, the council cannot make this decision. $600,000 in legal costs have been literally down the drain, Nunz.
Yeah, that's what I was going to ask. Just look, $600,000 in fees the council have spent on this. Was it worth it? You've got to ask the question, and there's also a question of whether they've got the power to put the dog down. What's your view on it?
Yeah, look, I think you touched on two really important points there, Nunzio. One, the legal fees, where there were other avenues available perhaps to reach an agreement. And two, the whether or not council had exercised their powers correctly, which it seems in this case the bias must have been so obvious to everybody that the High Court unanimously agreed.
Unfortunately, poor little Izzy, I understand, is still in jail, locked up, awaiting again her fate.
Really?
It just shows, I think we've spoken about these issues a lot on the show, and the Domestic Animals Act, and it's sort of polarised the community because they haven't got the divide between penalising and also trying to make sure that everyone gets a good outcome out of it, because it is a difficult one. It's a widespread issue, but we get a lot of the dog attack cases at the firm, and it's great that when you can compensate for the injuries, but you don't want dogs being put down there.
No.
So. Jess, before we go into the next break, GP fails to save friend. It's a good lead into the next segment.
Yeah, that's right, Nunzio. This is a really unfortunate case where a GP, who I believe was a family friend of the deceased person and also the husband of the deceased person, he was phoned because the husband found his wife pretty much unresponsive, and he attended the house and was informed that she'd taken about 12 sleeping tablets or the like, and his advice was, well, just monitor her for the next 12 hours, and if her condition worsens, call an ambulance, which occurred, but unfortunately it was beyond the point that she could have been recovered.
Viewers, it's a classic case of there's no shame in when you're injured. Just go to the hospital. It's really, there's no shame if someone's injured, taken an overdose. You need to deal with these situations. It's a life and death scenario.
Yeah, I'm just stunned. Obviously there's a case brought to VCAT against the GP for his failure to basically take the next step. I'm just stunned why 12 painkillers he wouldn't call an ambulance or take to the hospital.
Exactly.
He basically said he was embarrassed, but I don't know. Look, he avoided suspension. I think he was very lucky, but anyway. So there we go. But viewers, we need to go to a sponsors break. Next up, we'll be giving you a medical negligence update. Welcome back, viewers. Tonight's a medical negligence update, and we've got some interesting cases to present to the viewers. First up, though, John, James Peters. It's an awful story.
Awful case, Nunzio. James Peters, an anaesthetist. He was working at the Croydon Day Surgery, started in 2006. He was injecting himself with a drug called fentanyl, a painkiller, and he did it 55 times. The problem was he was using the same injection syringe on patients. Now, he was found out, as you know, there's issues of infection, issues of HIV risk, hepatitis, which is a fact. He was found out, he was prosecuted, taken to the Magistrates Court of Victoria. He pled guilty to 55 charges relating to the misappropriation, in this case, of the syringe for personal use and for the use of clients.
And how long was the sentence that he was given, John?
He was given 14 years, 10 years non-parole. It's a lengthy sentence, but now there's a civil action.
That's right. Look, so just give a bit of background. So there was initial proceedings against, effectively a class action against the day surgery, the practice boss, and also APRA. What happened there?
Yeah, so a class action was brought on behalf of the 55-odd claimants, Nunzio, and like you said, proceedings were brought against the practice itself and the regulation body for failing to pick up on the activities of the doctor in this case. A settlement amount of about 13 odd million was achieved and was to be split between the group of claimants in that case. And they're now bringing action personally against the doctor.
So just now they're taking separate proceedings against James Peters. So why wouldn't have he been part of the initial proceeding or class action?
Yeah, well, it's an interesting point, and look, I would have thought that his insurance coverage wouldn't have included the criminal acts, so that's likely why they're going against him personally in this case.
So, Nunzio, in this case, class action is being brought by Slater and Gordon.
That's right.
On behalf of 54 claimants, personally against James Peters. They probably found that he has assets and they're going after him.
Yeah, it's interesting because he said via video link that he doesn't have legal representation, which you can infer that he either doesn't have money or because, to be frank, he's pleaded guilty that there's nothing to defend, so you actually don't need to pay a lawyer.
Exactly.
Look, I do hope he's got substantial assets because these infected people deserve as much money as possible.
Exactly.
So there's more to come on that. But just, look, usually the process of the medical negligence case is obviously you've got to prove your fault, but then you've got to get over the 5% impairment threshold. Yeah. Now, in this case, because James Peters has pleaded guilty and has accepted that he negligently caused serious injury, do these claimants or plaintiffs require the 5%?
Well, in this case, Nunzio, what the courts looked at is the varying degrees of infection that they've sustained and the varying symptoms. So I think it's a difficult task in being able to apportion that by the court, but there are certain factors where they need to demonstrate common elements.
Yeah. No, but I would think that because he's pleaded guilty, they don't have to prove the 5%. It's what's called an intentional tort.
Yeah.
So they don't have to get over that threshold, but time will tell in that regard. Next case is that of the Medical Board of Australia versus Dr. O'Toole. So Jess, do you want to give us some facts on this one?
Look, this is another really unfortunate case where the plaintiff in this case had started consulting with Dr. O'Toole in about 1997, so quite early on in the piece. He'd presented with a background of chronic pain, Nunzio, which can develop after having a series of serious injuries, which occurred in this case.
Because he was an ex-jockey.
That's correct, yeah. So he had a few falls off the horse about 3 times and severe back injuries.
So he's suffering from chronic pain?
Correct, yeah. And when he presented to the doctor, the doctor had diagnosed him with an addiction to pethidine and said, look, we better wean you off this drug and we'll start you on a methadone program, which he did for about 10 or 8 to 10 years. And in about 2005, he decided to start him on a morphine-based program. The difficulty with that was that he had to inject it himself.
Self-administering.
Self-administering morphine. And then from then on, a flurry of unfortunate circumstances unfolded.
And this went on for years, didn't it, Jess?
Yeah, so he was consulting...
The morphine treatment went on for years.
Yeah, for about 18 months, so just under 2 years.
But I guess, and in the end, unfortunately, the client died and there was an issue about supervision, wasn't there?
Yeah, that's exactly right. And whilst 18 months seems like a short span of time, he was administering them at least on a daily basis and in the same injection spot. And like you said, lack of supervision in that case unfortunately led to the skin to rot effectively. And he developed a severe infection where he passed away within the span of 4 days effectively.
He got paralysis and then...
Yeah.
It was on palliative care.
Yeah.
So there was a coroner's inquest and there was a finding. What was the finding?
That's correct. So the finding was, there was some strong statements made by the coroner, I thought, and effectively the coroner stated that Dr. O'Toole had contributed to the plaintiff's death. which are very strong words
Yeah.
to state.
It's a difficult one, just because the coroner Spanos was saying that the doctor's conduct was a contributing factor, wasn't the factor.
Yep.
And interesting enough, basically, the coroner's allowed APRA to say, well, have a crack at Dr. O'Toole, which I think is not a good sign.
Yeah. Well, I think the coroner was left no choice, because he had doctors give evidence to say that they don't support that type of practice. And I guess it was almost left open to say that this was inevitable.
So does that mean that the family members of this particular plaintiff, that the name hasn't been disclosed, has an action?
That could be, oh yes, for nervous shock.
Yeah.
Exactly.
What's required to be proven?
Nunzio, firstly, there has to be pure psychological shock, a pure psychological injury. But then there also has to be foreseeability, as in people are on notice that as a result of these actions, this other person could suffer severe psychological injury.
Yeah, it's got to be a close sort of link. Some random on the street just can't make a claim for this. It's got to be someone who's got a link to the deceased and arguably can have a case. So, look, there could be more to come there, but we'll see how we go.
Exactly.
Viewers, we need to go to a sponsors break, but when we come back, we've got 3 other interesting cases to touch on. Welcome back, viewers. On our third case, which is that of Smythe v Bergman, New South Wales Supreme Court case. Jess, what happened here?
So, Nunzio, in this case, the plaintiff presented to her GP and had complaints about pain in her leg. It was a non-specific type pain. The GP undertook an examination, assessed the leg as you normally would, and eventually diagnosed her with a potential infection. Some 8 days later, she presented again and complained of the same type of pain. She gave her another course of antibiotics at this point. 7 days later, she presents to a different GP because her current one wasn't available. It seemed that there was a change in condition at this point, and she was sent to hospital. Unfortunately, what ended up resulting was that she'd had to have her leg amputated because the ultimate diagnosis was a blood clot in the leg and not an infection. And the plaintiff brought proceedings against the GP saying, well, you should have picked that up at point A as opposed to later on in the piece.
So basically, this plaintiff here is saying, because of those 2 attendances, Dr. Bergman should have noticed what was happening, should have done the due inquiries and put this to bed effectively.
Yep, pretty much.
John, what did the court find?
Court found against, unfortunately, the patient. Even though she's lost her leg, the court found that the doctor acted reasonably.
Yep.
Now, in particular, Nunzio, came down to 2 medical examinations and whether or not the pulse was checked and issues arising out of that.
What readings that came out?
Exactly. It's very detailed, isn't it? In the sense it's very precise.
Look, I think this is just another lesson to the viewers. Look, medical negligence, the hardest part about it is proving fault against the doctor, the hospital, the practitioner, and it requires so much medical literature involved, and so it's hard.
Nunzio, in this case, the patient requires to prove on the balance of probabilities that this doctor did not act reasonably.
It fell below what was a reasonable standard of that GP.
The reasonable standard of a GP being what, well, a normal GP would have done in this instance.
Yeah.
Now, the court found that the treatment afforded on those 2 particular occasions was reasonable.
Everything was done?
Yeah, and there was evidence to that effect saying that she'd undertaken the examination on the first occasion, so she didn't need to undertake it on the second. And in light of the facts before the doctor, she did everything a prudent practitioner would have done. The other point the court raised was that they didn't accept the plaintiff's evidence on a lot of points, so it became a credibility issue as well.
Look, both parties would have got reports from independent GPs, and look, unfortunately for the plaintiff, the doctor's evidence of an independent GP would have swayed the court's favour. So it's just another lesson that they're very difficult cases, but you need to see a lawyer to get the advice whether you do have a plausible case or a viable case.
Yeah.
Exactly.
Next case, John, you're interested in this one. Sweaty palms.
Yes, sweaty palms.
Moroz v Marshman. What's sweaty palms?
Again, the New South Wales Supreme Court. Fortunately, I don't suffer from sweaty palms. Unfortunately, this poor lady here does. And to the point where she wanted to do something about it. She's gone and seen a vascular surgeon who's an expert in this sweaty palm condition. Now, surgery was performed. However, the outcome was disastrous. She suffered severe complications, pain and suffering. I think there were statements that she felt like she was not a real person, a zombie.
She was worse effectively than what she was pre-surgery.
Exactly. Now, she sued in negligence against Dr. Marshman. However, the court disagreed with her actions.
So, Jess, obviously, Miss Moroz unfortunately wasn't successful, but what was the basis of the court findings?
Yeah, so just by way of background, this is what us practitioners would call a failure to warn case, and that was the basis of Miss Moroz's action. So as a result of the surgery, she'd suffered a lot of irreversible symptoms, and her complaint was that the doctor failed to warn her that she could have suffered these symptoms. And the court effectively found two things. One, that he had warned her, and the doctor had formed the view that she was well versed on the matter. She'd read up on the procedure, knew what the risks were and accepted them. And the second was that the other risks that he hadn't informed her of, the doctor wasn't actually required to tell her of those risks.
So that's an interesting one, John. Miss Moroz was well versed. She's read up on it. We get a lot of clients who come into our office who are well versed in the
sophisticated
law.
clients.
But ultimately, we're the lawyers. We give the advice, and same as the doctor. I'm not assailed by that argument that she was well versed, so she was aware of the risks.
It's quite harsh. It's quite harsh. We've got a scenario here where, in the end, the patient is relying upon and trusting upon an expert surgeon. Now, I would have thought that the outcomes here were so grossly out of proportion to what any reasonable warning would have been that maybe the plaintiff should have succeeded here. However, the court found that the doctor in this case had given all prudent and reasonable warnings. And I guess in the end, and this is what doctors all over Australia would be saying, well, what else can I do?
Yeah.
But Jess, do you think if she was aware of all these conditions that might happen, she still would have undertaken the surgery?
Yeah, well, that's an aspect the court considered. So for her to win on that argument, she would have had to prove or convince the court that she wouldn't have gone ahead with the surgery. And it's interesting, the court likened this procedure to a cosmetic procedure and said, well, if we're going to crack down on these types of procedures, then no one would go ahead with the cosmetic procedure.
I don't think it's cosmetic. When you look at the symptoms she was suffering, I think it was more than cosmetic. But look, it's a discussion for another day.
Yeah.
Finally, we've got one more case, Justice v Reid, Jess. It's an Adelaide case. We don't have too many of those, but do you want to quickly tell the viewers what happened here?
Yeah, certainly. So it's fitting actually because we're just talking about cosmetic procedures, and this is another example of one where the plaintiff effectively went in for a breast augmentation surgery and the doctor was found, I guess, liable for inserting breast implants that were too large and failing to remove them as soon as the plaintiff developed an infection. In this case, the defendant had defaulted, which meant they didn't respond to the arguments and couldn't effectively defend their case. So the court just made an assessment, which means, viewers, that the court just looks at what this claim could potentially...
What the losses are.
Yeah.
So Dr. Reid did not defend this claim?
That's right.
Okay.
And what was the finding in terms of damages, John?
In total, $84,000 was awarded to the client, to this unfortunate girl. Not a lot of money.
Look, it was only 40,000 for pain and suffering. Look, we probably don't know enough about her condition, but look, it seems a bit light on. But look, that's a discussion for another day. Thanks, John. Thanks, Jess. Viewers, please look at the past episodes, log onto our social media platforms and our website, and see you next week.